Good afternoon and welcome everybody to the CFEGA Lunch and Learn webinar, COVID-19 Legal Considerations for Colorado Agriculture Employers and Employees. I'm Adrian Card with Colorado State University Extension and board member of the Colorado Fruit and Vegetable Growers Association, and I'll be your host for today's webinar. Today we'll focus on helping you learn employment legal considerations for COVID-19, whether you're an ag employer or an employee. CFEGA is the go-to resource for Colorado's fresh fruit and vegetable farmers. We connect Colorado growers with industry, government, academia, and consumers to strengthen and expand Colorado fresh fruit and vegetable production. Learn more at coloradoproduce.org and follow us on Facebook and Instagram. CFEGA would like to acknowledge its sponsors today before we get started. Platinum level sponsors John Deere, Western Growers. Gold level sponsors Agfinity, American Ag Credit, Food Maven, and Cicada Farms. Silver sponsors Aquatic Resources, Bijou Seeds, Certis USA, Colorado Potatoes, Decade Products, D-Line Box and Display, DeSanti Farms, Fagerbird Produce, Gowan Seed, Holler Seed, Farm Credit of Southern Colorado, Hiracata Farms, King Supers, Landmark Packaging, Millburger Farms, Monte Vista Co-op, Nature Safe, Netafim, J&J Supply, Organic Supply, PSL Law Group, Rocky Mountain Farmers Union, Seedway, Strohauer Farms, Target, The Packer, TNT Packaging, Valley Irrigation of Greeley, Western Sayre, and Whole Foods. A little bit of housekeeping today before we get started to make sure you have optimal experience. There have been some past disruptive behaviors of people bombing Zoom webinars, for lack of a better word. So mostly that seems to be fixed within this platform, but if we encounter it today, I'll do my best to remove that individual, and if I can't, I'll end the webinar immediately and we'll do our best to regroup. Your primary portal for interaction today, I want all of our attendees to find this. Look at the toolbar and you'll find a Q&A button. Go ahead and click on that button and a Q&A box will pop out. That's going to be your primary place where you and others are going to interact with our presenters today. So encourage you to monitor that. You can see what questions are being asked. We will do our best to answer those during the presentation, but likely most of those are going to get answered after the presentation. You can resize your Zoom window as you would like. You can click the upper right buttons to change between full view or minimized view. And finally, at the end of the webinar, to determine our educational outcomes, I'll launch a poll and you'll see it similar to the Q&A box appear on your screen. It'll be multiple choice, and if you could help fill out those responses, that would be great. We are recording this, and the recording will be posted to coloradoproduce.org/COVID-19. Very pleased today to have presenters from JacksonLewis. Kathleen O'Grady is an associate in the Denver, Colorado office of JacksonLewis, PC. Her practice focuses on representing employers in workplace law matters, including single plaintiff discrimination and single plaintiff wage and hour cases. Ms. O'Grady is the Denver office's designated disability, leave, and health management attorney. Her clients include healthcare companies, financial service companies, federal contractors, among others. Additionally, Jonathan Siegel is the principal in the Orange County, California office of JacksonLewis. He practices before the Equal Employment Opportunity Commission, National Labor Relations Board, state and federal agencies and courts. Mr. Siegel also provides advice and counsel regarding labor and employment law with respect to various issues, including wage and hour law, reduction in workforce, WARN Act, discipline, leave management, harassment, and discrimination issues. Katie and John, thanks so much for being with us today. And Jonathan, at this point, I'll pass over screen share to you.
Thank you, and I want to say hello to everyone. Katie O'Grady and I are excited to be part of Colorado Fruit and Vegetable Growers Association webinar series. We have a great topic today, COVID-19 legal considerations for Colorado employers. And we also have an ambitious agenda. We have some hot off the press stuff that we wanted to talk about. We also wanted to review Colorado paid sick leave requirements and some of the other key details of the new Colorado requirement, and then also some liabilities and document retention issues. We hope that we can review the key parts of the Colorado law and answer any questions you have today. Let's talk about some quick updates. When we talk about hot off the press, things are happening so quickly now that what seems like hot off the press just a week or two ago is old news. But one of the things we wanted to touch base on was a recent report by the United States Department of Labor. The DOL put out a report talking about the 30% increase in OSHA retaliation complaints. We know, for everyone on the call, that safety is the #1 priority for you and for your employees and for your customers, especially in this time. But it is important to note that there is an increase in COVID-19 retaliation claims. And so it's really important when people raise their voice or bring a concern to follow your procedures, to engage in good safety practices, and obviously make sure no one's treated differently for raising such an important safety concern. What's another hot off the press update? Uh, there's a new checklist out. The FDA, the CDC, and OSHA have joined together to put out 16-page checklist on safety with respect to human and animal food operations during the pandemic. There's nothing better than a good checklist, and this checklist is available on Colorado Food and Growers website. It's also available at the FDA, CDC, and OSHA. And the checklist has active links in it, which is a lot of fun and makes things very easy. So if you haven't seen it, we really recommend you check it out. Also remember that really this is governing many of the federal requirements. You also still have your state requirements in Colorado to follow, and you want to look at that. The third important update is something that's going on all over the state right now, all over the country right now. Uh, what do we have? We have people going back to school, kids going back to school, schools reopening. And when we talk about that, if you have to comply, which many of you do, with the Federal Family First Act, the FFCRA, there are provisions specifically regarding the how to deal with the opening of the schools. If you've never gone to the DOL website regarding the FFCRA, they have a tremendous question and answer section, more than 100 Q&As there regarding all different aspects of the law. And they posted several new ones, really numbers 98, 99, and 100. And they specifically deal with when does the law apply and the provisions regarding paid child care leave apply, or when they can take sick leave with school reopening. And one of the changes or clarifications was that when you have children working remotely in a hybrid learning method, the time where they're working remotely, they can use, if the employee is eligible, for FFCRA sick leave or leave. Um, Now, if there are points where they should be in person, but they're choosing to work from home, then that the DOL is taking the position they would not be eligible. If the entire year is or beginning of the year is remote learning, then employees, when it's all remote learning, would be eligible for sick leave. So just be mindful of that. I'm going to turn it over at this point for Katie O'Grady to take the lead on taking you through Colorado paid sick leave. Katie's right in Denver, for those of you who are in the area.
Hi, this is Katie O'Grady. It's a pleasure to be here with you today. So as John mentioned, I'm going to go over the Colorado's new sick leave requirements. So it's called the Healthy Families and Workplaces Act. So prior to COVID, Colorado did not require that employers provide sick leave, and so this is a new thing for Colorado. So this law applies to all Colorado employers, and the legislation is twofold in that there are two, or actually rather three, effective dates of this act. So the portion of the act that went into effect on July 15th, 2020, and is effective now, is the requirement that employers comply with the Emergency Paid Sick Leave Act of the Families First Coronavirus Response Act, or the FFCRA, which, as many of you probably know, is a federal law that is in effect through the end of the year. So our employer clients who had not had to comply with the FFCRA, or often employers with 500 or more employees, often ask whether they are required to comply with the expanded FMLA portion of the FFCRA, which provides 12 weeks of leave for an employee who has a child whose place of care is closed due to COVID. And the answer is no, that only the Emergency Paid Sick Leave Act of the FFCRA is required by this Colorado legislation. And unlike the Emergency Paid Sick Leave Act of the FFCRA, there unfortunately is no tax credit under the Healthy Families and Workplaces Act. And as I mentioned, it applies to all employers regardless of size, and there is no healthcare exemption, although that doesn't apply to you anyway, but either way. So the Healthy Family Workplaces Act requires that it replaces the Colorado HELP rules, which provided 2 weeks or up to a maximum of 80 hours of paid sick leave at 2/3 of an employee's regular rate of pay for COVID-related reasons. So those Colorado HELP rules, their effective date ended just the day before, so July 14th, the day before this legislation went into effect. And it's actually easiest to think of this legislation in two parts, since the portion of the act that is effective now only goes through the end of this year, and therefore at the beginning of next year you can actually forget about all of the requirements that are effective now. So just a brief overview. So as I mentioned in the previous slide, it applies to all employers, and unlike the FFCRA, small businesses cannot apply for an exemption due to a undue hardship providing this leave. However, a collective bargain agreement can depart from the Healthy Families Workplaces Act requirement that leave must be in hourly increments, but it cannot eliminate an employee's right to take leave without interference, or and can also not interfere with an employee's right to file a complaint if they feel like the employer has violated the Healthy Families Workplace Act. So for all your employer, for those who have already been complying with the Emergency Paid Sick Leave Act of the FFCRA, the Healthy Family Workplaces Act does not create any additional obligations apart from posting requirements, which I'll go over later. And employers who already provided 80 hours of leave in 2020 do not need to provide an additional 80 hours of leave. For example, if an employer already provided 80 hours of leave at full pay for a qualifying COVID-related reason in April 2020, they do not need to provide an additional 80 hours of leave now. And right here are the 5 qualifying reasons that you could take leave, both under the FFCRA as well as the Colorado's new legislation. So just, John, if you don't mind, the next slide, please. So just an overview of what's required by the Emergency Paid Sick Leave Act, and thus the Healthy Families Workplace Act. I can't say this enough, but as I mentioned, if you already provided leave in 2020, you do not need to provide additional leave now. However, there are situations in which an employer will have to supplement leave in the event they did not provide an employee with their full leave entitlements. So I'll provide an example. So in April 2020, an employer gave an employee 2/3 pay for 2 weeks of quarantine for suspected COVID pursuant to the Colorado health rules, which only required that employees provide 2/3 pay. And then in October 2020, the employer actually gets COVID. The employee is entitled to leave, to take leave in October at full pay. However, the employer already provided paid leave in April that equates to 53 hours and 1/3, or 53 1/3 hours of the employee's regular rate, right? Because they provided two-thirds pay during that time. So therefore, in October, the employer must provide 26 2/3 hour leave, paid leave. So essentially that remaining 1/3, because that's what totals 80 hours of leave, and therefore an employee full regular rate of pay. Another example is in April 2020, if an employer gave an employee full 2/3 pay for 2 weeks for taking care of a child during a school closure, because that's 53 1/3 hours paid leave, the employer then asks for more paid leave in October 2020 for another school closure. The employee is not entitled to more paid leave because they have already received the maximum of leave for their child care, which is the 2/3 pay for 2 weeks. So again, there's not an additional requirement to give an additional 80 hours for leave you already provided. So actually, John, last slide, please. Similar to the FFCRA, there is a daily cap, and so for full rate of pay, it's going to be that 511 per day cap, or 5,110 in the aggregate. And then for those employees who are entitled to 2/3 pay, so for caring for a child for school closure or for caring for someone else based on COVID or healthcare direction, it's going to be a $200 per day maximum, and then $2,000 in the aggregate. And again, just that 2/3 rate of pay is required for the school closing. So any healthy families workplace act related health information that employers receive must be kept confidential in a separate file. Documentation is not required to take leave, but it can be required as soon as the employee reasonably can provide it. So employers cannot require that an employee give them a healthcare note or some sort of acknowledgement form that their child is out of school due to a school closure prior to taking leave. And so the employer can put the employee on leave and then request that documentation at a later date. So reasonable documentation includes, for instance, if an employee is out due to a child school closure, they can ask for the dates of leave, the name of the child, the name of the school, place of care, and a statement that no other suitable person is available for that child care. All right, next slide, please. So there is, as I mentioned, even for the employers who are already complying with the FFCRA, the emergency paid sick leave portion of the FFCRA, that there is still a notice requirement. And so there's a poster here, and there will be one that comes out next year for 2021. And so, but as of right now, this current poster must be posted in the workplace, any physical work site, and given to every employee, whether it's electronically or in handout form. In the event the employer gives the employee a handout form, we recommend that you get a signature, the employee's signature, or some sort of initial just acknowledging that the employee received this poster. And employers also must provide notices and posters in any language that is the first language spoken by at least 5% of its workforce. Additional posters and notices will be made available, as I mentioned, to comply with the notice requirements for 2021. And two, if I don't think I mentioned, when I mentioned that there were 3 effective dates, there's the effective date that went into effect July 15th, which requires, again, that employers comply with the Emergency Paid Sick Leave Act of the FFCRA. And then there's also, which I'll discuss in detail later, a requirement that employers provide sick leave, and that begins, that's for any reason, not just COVID. That kicks off at the first of the year for employers with 16 or more employees, and then employers with 15 or fewer employees, they're going to be required to provide sick leave beginning 2022. So they get smaller employers get an extra year to get their act together and provide a system for sick leave. And John, I'll turn it back to you now.
Yeah, and that was great information. And in terms of your obligation for the sick leave, when you talk about has there been any good that comes out of the pandemic, I think a lot more states are looking at developing mandatory sick leave laws, which I think help both the employer and the employees. And also, I think, help better manage an area that there was not a lot of regulation. And so the Colorado sick leave requirement starting January 1st for employers with 16 or more, they talk about, how do you accrue paid sick leave? You would accrue it under the policy 1 hour for every 30 hours worked, up to a cap of 48 hours. You can be more generous if you want. Exempt employees generally are viewed as assuming they're working 40 hours a week when you're trying to figure out that accrual. For reasons for taking accrued paid sick leave, these reasons are following many of the other state sick leave laws that have been growing out of this pandemic and this occurrence over the last couple of years of state sick leave laws. Why can you take sick leave? Why can the employee take sick leave? One is for their own mental or physical illness or injury. One of the things that is important to point out is mental, not just physical injuries apply. Sometimes organizations are not sensitive to mental disability or injury, so you just want to be mindful of that. It'll cover both mental or physical. It'll cover when employees seeking a diagnosis, and also cover preventive care. The employee can also use sick leave to care for a family member in all these 3 areas. But the Colorado sick leave is really dynamic because it goes beyond just that. There's a section that protects employees and their family members who are victims of domestic abuse, sexual assault, and sexual harassment, and different absences caused by those issues. Now, we hope domestic abuse and sexual assault you rarely have to deal with. Those are very serious issues. I think in the workplace, you probably see more of sexual harassment claims, and this will come up. So if you have someone making a claim for sexual harassment in the workplace, just keep in mind that as of January 1st, that's one of the reasons if they have to miss work, that they could take their sick leave. So now under domestic abuse, or sexual assault, or harassment, some of these reasons, obviously, for them to seek medical attention, but also when they're seeking help from victim services, health counseling, relocation, seeking legal services, or attending proceedings. That's very important. So there's many different reasons that could trigger the ability to use sick leave. What else? Well, there's more to this law. If there's a public health emergency and a public official has ordered closure of the employee's business or place of care for their children, they can use sick leave at that time. Now, you may be asking yourself, well, Katie, John, how often or how long do they have to take sick leave? maybe you're not asking that, but we're going to talk about that. Employees can take sick leave or should take sick leave in 1 hour increments. They can take it in smaller increments if the employer allows it, depending on your payroll system. You can also advance sick leave to employees who have not accrued it. That's also permissible. Although this rarely happens, you can't require an employee to find a replacement worker um, before they take their sick leave. Now, another issue that comes up a lot in sick leave law management is, what do you do at the end of the year? Well, an employee is accruing 1 hour for every 30 hours worked. And at the end of the year, any unused accrued sick leave will carry over up to a cap of 48 hours. So again, at the end of the year, they'll carry over up to a cap of 48 hours. Now, on the other side, if an employer would like, they can limit the use of paid sick leave up to 48 hours a year. So those are two different things. One is a carryover and cap, and the other one is if you want to limit sick leave, you can up to 48 hours. But however, even if you limit them 48, if they have unused time, it would carry over. Now, the Colorado paid sick leave also is dynamic in that it has a public health emergency provision, which is unique. So this is different benefit than what we've been talking about. This is a one-time grant of sick leave in the event of a future public health emergency, something similar to what we're dealing with now. What is this is that they are entitled to take at least 80 hours of paid sick leave for public health emergencies. Now, any sick leave they've already accrued under your policies, you could take a credit towards that 80 hours, but then they would get the difference of that. The unique public health emergency sick leave benefit an employee could take if they have to self-isolate themselves, if they have to get medical treatment, if they have to get preventive care, if they have to care for a family member who has any of those kind of needs. But it goes beyond that. Also, if a public health official, federal or state or local, determines that an employee's presence on the job is jeopardizing the health, then they could take this unique public health emergency sick leave. Same if they have to care for a family member who, or to care for a child whose child care provider is not available. All those would be reasons to take this unique one-time benefit. So those are some of the unique areas of the Colorado sick leave law that will go into effect January 1st. Now, to talk about the most exciting part of our webinar, the record keeping, documentation, and liability, Katie O'Grady is going to come back in to take you through that area.
Yeah, great, thanks. So requests for accrued paid sick leave must be made orally in writing, electronically, or by any other means acceptable to the employer. When possible, the employee must include the expected duration of the absence, and an employer may adopt a written policy that contains reasonable procedures for the employee to provide notice when the use of paid sick leave taken under the Healthy Families Workplace Act is foreseeable. However, an employer cannot deny paid sick leave to an employee based on non-compliance with such a policy. So when the leave is foreseeable, employees should make a good faith effort to provide notice to the employer and make a reasonable effort to schedule paid sick leave in a manner that does not unduly disrupt business operations. And so, as the slide mentions, employers must retain records for 2-year period documenting the hours worked, paid sick leave accrued, and paid sick leave used. And employers may not request documentation for sick leave for less than 4 days, but 4 days or more, they can request documentation just indicating that the employee was taking leave for a qualifying reason. However, and John may have mentioned this already, but an employer cannot request documentation for leave related to a public health emergency, which is sort of unlike what is effective now, in which employers can at least ask for some sort of acknowledgement that they are not going to be able to ask for that same documentation in the event of a public health emergency next year, or in 2022 for employers with 15 or fewer employees. So potential liabilities. So a person who believes that they have been either retaliated against or have been unlawfully denied leave under the Healthy Families Workplace Act may commence a civil action in district court no later than 2 years after the violation occurs. And a violation occurs on each occasion that a person is affected by a failure to provide paid sick leave or retaliated against for paid sick leave. And so that there's going to be an opportunity for, again, an employer to file an employee to file right in court, or the employee can also file an sort of an administrative charge through the Division of Labor Standards and Statistics. However, if an employer chooses to go and file right in court, they do have to provide the employer with notice and give them an opportunity, at least 14 days, for the employer to respond. An example of where an employer would not be liable for retaliation is as follows. And say an employer grants an employee a request for paid leave for a COVID test, but then learned that the employee went bowling and never had that appointment. The employer then denies the request for paid leave and fires the employee for dishonest misuse of leave. And then say the employee files a complaint claiming that the denial of paid leave and retaliation against their Healthy Family Workplace rights. The employer did nothing wrong because leave was not for a Healthy Family Workplace purpose, and firing was not retaliation because by taking leave with no Healthy Family Workplace purpose, the employee did not act reasonably or in good faith. That's sort of an example in which an employer would not be, would not be liable. So just a few reminders when handling COVID situations. Do not forget about the ADA. Employers must still engage in the interactive process with employees with a disability. If an employee perceives, if you perceive an employee as infected, they may also be covered. Individuals associated with someone with a disability are covered. Employers may take temperatures. You all are probably already doing that because that's required in Colorado. And again, just a reminder to maintain confidentiality and keep the medical information private. And another reminder, employers are able to send an employee home if they believe that the employee might have COVID or showing symptoms. And so another thing just to keep in mind is, again, workers' compensation management. So employers should also continue to manage workers' comp issues and file claims as appropriate. There still has to be some proof of causation showing that the illness arose at work, and then we also included an article on that, and just a statistic that 1,262 COVID claims have been denied, and employers have admitted liability in 628 cases, as reported by the Denver Post. But oftentimes it's difficult to show that COVID arose at work, and it's usually in the healthcare setting that employees are having an easier time showing that they contracted COVID at work. And so thank you very much. We appreciate your time, and we will take any questions if anyone has any questions.
Thank you, John and Kathleen. And those of you still in our listening audience, if you would go to the Q&A box, and you can see that John's answered a couple of questions under the answered tab. He's typed in. One that I want to lead off with for you guys. Let's see, Jonathan got that one too. So yeah, so we'll go back to Laura's question. I realize this presentation is available in recorded format, but is there any way to provide the print version? Great question. We're going to also link in that same section of the website the recording and a PDF of these slides. So both of those will be available to you.
Great.
So hopefully these guys stirred some questions for you today regarding the plethora of different leave provisions that are out there. Invite you while we have them here. You saw they jumped over one previous slide, but this is a national law firm with great scope and understanding. So encourage you to, I don't think we call this free legal advice, John or Katie, but maybe some answering of questions while you're here today.
Yeah, we're happy to answer questions. And I thought the question Jackie asked about the Colorado sick leave, and we talked about 48 hours versus 80 hours. And, you know, as I said in my answer, there's two separate parts. There's you accrue 48 hours of sick leave, up to 48 hours. And then separately, there's this unique one-time benefit if we have a public health emergency again, where they could get up to 80 hours. But that's only if we have the public health emergency again, which we all hope we don't. So.
John, I'm just going to piggyback off that. So say an employee takes 80 hours of leave because they think that they've contracted COVID in December 2020, and they take that leave, and then say in January 2021, that employee again suspects that they have contracted COVID, and in the unfortunate event that COVID is still around in January, they could then get another 80 hours of leave, even though they had just taken it 80 hours of leave a month prior, because it's really going to restart the employer's obligation to provide leave. And so if the employee is seeking medical diagnosis in January because they think they contracted it again, then that employer is going to immediately have to provide that 80 hours of leave. However, the benefit is that say an employer front-loaded 48 hours of sick time, and then which means that an employer gave an employee or gives their employees an automatic 48 hours of sick leave at the first of the year. And then again, an employee believes in January 2021 that they've contracted COVID, the employer can deduct the 48 hours from the 80 hours that they are required to give. So there's that benefit, if that makes sense.
I think as a good business partner, for those on the call, you really want to make sure, human resources, your legal group or whoever's managing those issues is communicating with the finance people so they know, hey, come January 1st, we have this obligation. And then, by the way, there's this unique obligation if we have another public health emergency. And make sure the finance people have accounted for these kind of issues in your strategic planning. And on the other side, obviously you want to put together a policy, you want to make sure you have your poster, but you also want to make sure you do some really good manager training. So the frontline managers know what to do, what to look out for, what they can, what they can't do. None of us are worried about the people on the call because, you're getting the information. It's the folks who are frontline supervisors in the fields that, we want to be looking at and working with and making sure they're trained, because it's those field supervisors who really need the follow-up.
Great explanation. I'm going to read the next question here. And guys in our listening audience, also while these these two are answering the question. I'm going to launch a poll, so look for that. We'll kind of multitask here a bit in our final minute. So Danelle asks, can you discuss once more the signatures by all employees that's required on the work regarding the workplace poster and the dates?
So a lot of the employers are just providing a copy of this poster electronically. And so there's a record that they sent the employee a copy of this poster. However, for those employers who are providing their employees with handout copies, there's no requirement that they get a signature, but we just recommend that the employer has some sort of acknowledgement or just initials from the employee, just acknowledging that they did in fact receive a copy of the poster, just because there is that distribution obligation of that poster, both posted in the physical work site as well as disseminated to employees.
Great, thank you. Amy asks, can you share the link to the current required 2020 poster in the follow-up email with the presentation? Yeah, Amy, I can do that. I can get the participant list and send that out. And Katie, you had some thoughts on that?
Yeah, there is a copy of the poster on the Colorado Labor Standard and Statistics website. However, it oftentimes that website is fairly difficult to navigate, and so we did include a link to that poster in the slide as well. So just in case.
Great. And let's see, someone asked, can you ask for a doctor's note when someone requests sick leave? Can you request a return to work authorization after the employee has been off work for a certain number of days?
So you can, however, because of the overwhelming, clog of the healthcare system, though an employer can ask, it is best practice to accept an employee's acknowledgement that they saw a healthcare provider. And so though we can ask, the employee only is obligated to provide information regarding who they saw and an acknowledgement that they did see someone. But yes, we can ask for a return to work following an absence, though it's recommended that we're a bit more lax about what form is used. We recommend that if a healthcare provider sends out an email saying this employee is cleared to return to work, that the employer accept that as sufficient.
Great. Another person asks, can a condition of employment include the use of apps to assist in contact tracing, like the one the state of Colorado will be offering soon?
So, I am not. Sorry, can you repeat that, Adrian? I don't.
Can a condition of employment include the use of apps? So contact tracing apps that might show a person has been exposed. Could that be an indication that they are sick or should be quarantined?
So as of right now, the only requirement or condition of employment is that the employee conducts symptom screening, and so as of right now, you cannot require that the employee use the app as a condition of employment. However, it's possible that that may change based on perhaps when the app comes out. But as of right now, no, we cannot require that.
Okay, great. Danelle asks, if you have employees that do not use the 48 hours that have accrued, that carry over, do we have to pay it out to them, or is it lost?
No, so you do not have to pay out sick leave, and it's lost with just the minor caveat that if an employee separates from employment and is then rehired within 6 months, that whatever accrued unused sick time that the employee had prior to their separation is reinstated. But that's again only if the employee is rehired within 6 months. Otherwise, it is lost and no payout whatsoever.
Okay.
Which in ag, that could happen depending on the timing of the seasons. and crops, where people are getting laid off at the end of the season and then getting rehired if they're coming back for the next crop, or depending on your growing schedule. So that is something to be aware of. It's a 6-month window.
Okay. Jackie asked, can you ask for the test results from COVID-19, whether positive or negative?
We do not recommend that they actually need to provide a test result, but you can ask them about it, but it's not recommended that you require it at this time anyway.
Okay.
And I think you also have the caveat of you can ask for a doctor's note, but they're very hard to get from a practical standpoint. So you really want to follow CDC guidelines in terms of return to work, whether it's the symptom-based strategy or the test-based strategy. Be mindful of that. So people can get tests done, but you still want to follow the CDC guidelines, and you also don't need a test to return. You can follow the system-based strategy that CDC has put out there.
Great, guys. Well, I'm not seeing any more questions in the Q&A. We'll pause here just a moment to see if anyone else has a question before we adjourn. John and Katie, really appreciate you making time today to present. Pleasure to meet both of you. And for our viewing audience, this recording and a PDF of the slides will be available at coloradoproduce.org/COVID-19. So thanks to everyone and have a great day.
Great, thank you.